stubs, your W-2s, everything, please take them with you. There's nothing wrong with it. You don't have to carry physical documents. You can have them in electronic format also, but you make sure that you have all those things with you. Okay. And see, these are the things which I'm seeing a problem all the time with the F1 OPTs or STEM OPTs when they travel abroad and come back. And the other thing is, if they have any criminal infractions in their records, that can also cause a problem. Now these days, see, the problem is with the new generation coming into this country, I've seen somehow these children are participating into a lot of shoplifting, small petty thefts, larcenies, burglaries, these things. And those things can actually cause a huge problem for you at the port of entry because they may consider as a crime involving moral turpitude, especially if it's anything involved with the fraud and misapprehension, anything involved with the financial crimes, they can be crimes involving moral turpitude, CIMT. And if it's a CIMT, and if it is punishable at least 6 months or more, and if you've been sentenced for 6 months or more, that can be used against you to remove from this country. Okay. Now, with the Lake and Riley Act, even it's not even required to be a CIMT. Even if it's a petty theft, even if the theft is a value of $100, simple theft of any good that is value of $100, and they can actually render you inadmissible into this country while you're seeking re-entry into this country. And this is the problems which I'm seeing with lots of new generation coming into this country, and they have to make sure that leave those bad habits, everything in India. When you come here, make sure that what the laws are here, make sure what is the etiquette you have to follow here, and accordingly, you have to adjust yourself and make sure that you comply with the laws and regulations of here. And I've seen some students drive recklessly on the roads. They get reckless driving tickets, which are misdemeanors. But if they get more than one, that will cause them trouble too. These are the issues which we are seeing at the port of interest, mainly when they travel abroad and come back while they're in a fun OPT and STEM OPT, Santosh.
Oh,
And also make sure that if you're just don't get a letter from some employer because to show that you're maintaining valid F1 status in this country. Make sure who are they? Why are they giving you the letter? Are they paying? Are they taking any money from you to give you the letter, or they're giving you the letter because they're employed you really on STEM OPT and F1 OPT. This fraudulent there are a lot of companies out there who try to take advantage of you by charging you money, providing offer letter and everything, but actually you are not even working for them or you're not doing anything doing like that. Those things also can really backfire them. You know, they have to be very careful with those things also. F1 students, they have to have a complete knowledge on that. And F1 students overall to maintain valid status, sometimes the programs which they get admitted into also sometimes can be a trouble making programs. For instance, certain universities offers a hybrid programs, and if they do not have a proper accreditation and authorization for hybrid program, and if the students enroll in hybrid programs, that can cause a problem also because that can say that they fail to maintain F1 status because they were actually pursuing their education in a program that is not authorized by the service. So those are the things which they have to really look into carefully and get all the information properly. Do your homework exactly what you are doing and everything. And it's important. It's ignorance of law is no excuse. So you have to know everything pertaining to your immigration, and you are the one who can actually control your immigration, nobody else. And other mistakes I've seen with a lot of F1 OPT students and STEM OPT students when they travel abroad and come back is for the duration of unemployment days they have on their status, right? See, most of the students think that they can be unemployed up to 150 days on an aggregate for the entire duration of STEM OPT and initial OPT. It's incorrect. I mean, it is correct inside one sentence, but it's incorrect. Why it is incorrect is there is a restriction on how many days you can be unemployed on initial OPT and how many days you can be unemployed in a STEM OPT. Okay, the requirements are that you cannot be unemployed not more than 90 days in initial OPT, and you cannot be unemployed not more than 60 days in STEM OPT. So aggregate it's 150 days, but 90 days in initial OPT and 60 days in STEM OPT. If you have one extra day unemployment also in initial OPT or beyond 90 days, you are out of status. Same thing with STEM OPT also. You may be leaving, you may have taken only 70 days in initial OPT, but if you have taken 61 days and above in STEM OPT, you're out of status in STEM OPT. It is not aggregate of 150. So that is a big mistake which a lot of students do, you know. And other thing, those are the problems which we have seen at the port of entries for a lot of students, when they come in. And other problems we have seen is some students are very, God bless them, and I'm very glad that we have some smart students coming into this country, because that shows what kind of a pool we have from India, what kind of a talent pool we have from India, and everything. And these students do multiple jobs while they're in F1 OPT and STEM OPT, but they fail to inform their school DSOs, and they don't get proper authorized I-20s to work for both employers at the same time. And if they don't, then they're in violation of their status. And they're mandatorily required to obtain authorization to work for both employers at the same time, because there's no restriction that they cannot work for multiple employers when they're an OPT or STEM OPT. They can work, but it has to be properly authorized by the school DSO. And during the STEM OPT also, they have to properly submit their service I-93 form to the school DSO. And also they have to timely submit their evaluation forms also every 6 months and every 1 year, from the employer to the school. And if they fail to do that, those things also will enter a problem for them while they're coming back, while they travel abroad and coming back into this country. See, these are all the factors are there which are really causing troubles at the port of entry. That's what. Not every case is a genuine case which was sent back in port of entry. Of course, we have seen certain cases which happened that way. When those things happen, we were able to get them apply for a visa again abroad and able to bring them back into the US, because we were able to clearly establish that officer was wrong and erroneous in denying the admission to them in this country.
లైట్ వేసుకోవడం కూడా తెలియదా గీత నువ్వు ఈ చిన్నపిల్లవా?
Okay,
ఇట్స్
so
నాట్ ఓకే ఫర్ యువర్ ఐస్ బేటా. నీకు చాలా చెప్తున్నా, లైట్.
Can you mute everybody?
yeah.
Yeah, I just muted them, so sorry for that.
Okay, fine. Thanks. Thanks, Banu. Banu, if in that case, in some such situation, they are in, they got into the room, they call into the room while into the port of entry. What is the fastest step students able to do it, and how you can able to support them to sometime mistakenly happen something, or you can able to support them? What are the steps they have to do for take care of them?
Yeah, first thing is don't panic.
Mm-hmm.
My always is this: if you have taken to secondary inspection, don't panic. Just think it as if it's a normal inspection for you. Going to the second inspection, they might ask the same question in different formats from you to get the information from you, so that they can actually make you removable from this country. Don't admit any of the information if they are forcing to admit, which will actually incriminate against you because of the violation of immigration laws. Okay? It's very, very important. You have to be calm, composed, and do not admit anything. And do not sign any document without reading it or anything like that. Don't get scared. That's my whole point is, if they're threatening you that I know you worked here, you know you worked there, I know you worked there, you don't have to be lying to them. You don't have to admit that unless they have an evidence against you on that. If they say that they have an evidence, so ask them, please show me the evidence what you have against me that I worked over there. I'm telling you that I never worked.
Mm-hmm.
Okay? And or something like that, it's very, very important to have all these evidence, all these documents and everything. Despite that, if they place you in expedited removal proceeding means they decided that to send you back home at the time, you can actually ask them, instead of them removing you, you will withdraw your application for admission into the United States so that you can go abroad again, apply for a visa, and then come back.
Okay.
That is a very important thing to do. Unfortunately, what happens at the port of entry is you're seeking an admission into the United States. You have not been admitted into the United States yet. And because of that, in the expedited removal proceedings, as far as my knowledge is concerned, I may be wrong, but I vaguely remember that you do not have a right to represent an attorney under Section 236 or 237 of the INA. Okay? And I can be wrong with it, but that's a possibility. But Some lawyers are telling them to carry the G28 with them and provide the G28 with them so that it may work for them at the port of entries. There's nothing wrong in trying that. There's nothing wrong in making an attempt towards it. But I'm not sure how effective or impactful that will be. But there's nothing wrong in trying that.
So they have to defend on themselves. There's nothing support from the external attorneys.
Most of the times, unfortunately, it won't happen because they have no right to an attorney at the time, because due process is not available for them because they have not been admitted into the United States yet. Only the time they can be actually eligible for the due process is if they express fear of persecution, credible fear of persecution or a death to them if they return to the home country. Then they cannot really place them in expedited removal proceedings. They have to place them in the removal proceedings and make them appear before the immigration judge. At that time, they'll have a right to a counsel, and the counsel can fight for them because they're seeking a refugee or asylum into this country because they have a fear of persecution, credible fear of persecution or a death if they return back to their home country.
Okay. But in OPT session, I have one more last question. So during this, they join in a consultancy for enrolling to get an STEM OPT or OPT. What are the working assignments they need to perform so that what USAS exactly looks into the OPT students, what actually any feedback forms or any assignments, or what are the things they look for from the OPT student is really working, and what are the deliverables they are showing? Do you have any insight to at least give us so that our students knows what are things they have to perform?
It all depends upon what the job they're working on, right? And if they're given an offer letter to the school that this is the job with this employer and these are my responsibilities, blah, and this is what I'm doing on OPT, then they have to establish that they were in fact working in the particular job, performing those responsibilities. So it's important for them to work with that employer and gather such information, what is needed for them to prove that they were actually in working with them. For example, if the employer gives them an offer letter saying that he's a software developer and is involved into SDLC and all of the responsibilities over there, then they have to establish whether he's really working that or not. Okay, and so make sure that employer and they have certain kind of a communication process on how the training is provided, how the job tasks are issued to them. Those things are very, very important. I think those things can be asked sometimes at the port of entry if they suspect that individual is actually not doing any job for the employer in the job for which their OPT has been obtained for.
Do you see any RFEs related to the documentation part? Can you please provide me
I
the
mean, yeah, we definitely see that.
find the USCIS ask the questions.
Yeah, we definitely see that. But sometimes, as I told you, on a case-by-case basis, we review the RFEs and then we provide what is relevant or what is required information for those RFEs. As I told you, USAS tends to cross the line all the time. They can ask many informations, right? Not only your W-2s, not only your financial documents, not only your bank statements, but your they can demand your client bank statements, client tax returns also sometimes.
Even companies 941 also they will ask.
Yeah. I mean, they can demand anything they want to demand, but we have to make sure what is relevant information that is required for us to provide to get the approval. I've seen some RFs asking that you need to provide your client and client supervisors tax returns and bank statements. That's ridiculous, basically, right? And why will a client will give their financial documents to the employee to get his STEM OPT, right? See, the point is if you let anybody to ask you anything, they can ask you anything because it's getting free for them, right? So they do that. But point is, if you try to provide every information what they ask you and provide you, even if that information is not relevant, the same information can be used against you to deny the benefit you are seeking or revoke the benefit you are seeking. Okay, so you have to understand that. That's very, very important. So you just because they asked it, it doesn't mean that it's legally correct. That's what I wanted. That's what I'm trying to tell you.
Okay, thank you. And thanks, Manu, for OPT session. We had a elaborate session on OPT. You have given a lot of insight on the do's and do nots of OPT and how they can be successful in doing their duties as an OPT or a STEM OPT things, and as well as on the port of entry as well. Now, please ask guys and OPT or STEM OPT students, please ask any questions you have in the chat so that we can ask in Q&A session. Now we will be switch on to our main important aspects of H1, H4, and as well as H4 EAD. So these are all the three important, and I think majority of our participants are part of this area where we would like to ask a few questions related to that. And uh, basically on January 17th, as then you know that there are a lot of things have been happened during that time. And what during that time, and as well as on the new Trump administration, is there any new rules are coming up for H1 programs? I have three more questions. Have there been any alteration to the H1B visa application process, eligibility requirements, or an annual caps? Or are there any new policies regarding H1B visa holders working at third-party client sites or engaging in remote work? What steps should employer/employee should take to be compliant with updated H1B regulations? So, and as well as on the H1B program, H4 program, for the children, there is a new, I think there is a new rule came up recently on the alien registration initiatives for the kids who crossed around 14 years of age. They need to go for fingerprinting or biometric registrations and all. So we would like to know about all these areas of H1B programs. Try to be crisp as much as you can, as shortage of the time. That is very important. People are wants to know what's happening about this alien registration. Also, a lot of questions are getting on that area, but we'll go by step. First H1 or H1B new regulations and cap filing also for cap 2026 also coming up in March 7th going to start. What are the new regulations that are happening, and please enlighten us with the new regulations.
Yeah, sure, definitely. See, first I'll start with the simple thing about you're talking about the H4s, and you're talking about the H4s and H4 EADs, and if it comes to H4s and H4 EADs, hello, can you all
Go
hear
ahead,
me?
Manu.
Yes.
Yeah, yeah. If it comes to H4 and H4 EADs, no change in the regulations. They're same as in the past right now, and I don't think they are going to make any changes, at least for few months or few years. We don't know what Trump administration will do that. But as far as my understanding is concerned, they're not going to touch it. So they're going to adjudicate H4s and H4 EADs just like any other time, like what happens and everything. If it comes to H1Bs, we all know that H1B moderation rule made a significant changes to the H1B program requirements, especially the requirements to show how do you show a bona fide job offer exists between employer and employee uh, for the petition which they are filing, and also what are the requirements for the purpose of what position qualifies as a specialty occupation to become eligible for the H1B visa. And also, they made other changes also, where at what times we have to, and how do you document all those things. And also, they made changes to FD and site visit verifications also for H1B program. Okay, and those are the major changes happened in the H1B moderation rule. And you all know with the cap season coming in, the current cap for the fiscal year 2026 registration is going to start on March 7th, 12 noon Eastern time, and going to end on March 24th, 12 noon Eastern time. Only the major change happened with the cap registration is the fee increase per each beneficiary in order to submit a registration. Previous years, it was only $10 to submit lottery registration for on behalf of each employee. But now that fee has been increased to $215 per beneficiary to submit for the registration. And if it comes to selection of lottery process and everything remains same. It's still beneficiary centric practice centric based system. That means what what do you mean by beneficiary-centric selection process means if one beneficiary gets multiple registrations by unrelated employers, they all will be clubbed into as one registration for that beneficiary and then entered into the lottery system. And if it gets selected, then all those beneficiaries, employers will be notified that this beneficiary has been selected. That is why it's a beneficiary-centric selection system. That has been implemented last year. The same thing is continuing this year also. Okay. And the information required for the registration is minimal information, no changes, minimal information of an employer, minimal information employee to submit a successful registration for the lottery. Once the registration has been submitted, then the cap cases must be filed between April 1 to June 30th of 2025 with a minimum start date of with the initial start date of October 1, 2025 or onwards or beyond. Okay, depending upon when you're filing, you can ask to start date up to 180 days from the day you're filing your H1B petition. So that's why those are same requirements and everything. But if it comes to establishing the actual job offer, a bona fide job offer exists between employer and employee, those things have changed. We all know that in 2020, ITServe successfully won a lawsuit against the USCIS that actually forced the USCIS to design NUFL memo and the itinerary memo that requires employers to provide third-party client letters, agreements, purchase orders, and other documents to show that H1B is actually working in a specialty occupation. That was based upon the policy memorandums issued by the new USCIS in 2010, very famously known as NUFL memo, and the itinerary memo. Because those memos were issued unlawfully by the USCIS, ITServe was able to successfully litigate and win those cases. And after winning those cases, we as an employers and employees never had a problem getting H1Bs approved. We do not there was no requirement of us submitting those client letters or a client agreements, purchase orders, or any documents establishing relation between the employer and the third-party companies where actually beneficiary provides services. So we are getting approvals very smoothly. And also because of itinerary memo has been decided, there were no short-term approvals also. Any H1B we file, we're getting approved for 3 years. And so that was happening. And unfortunately, with the H1B moderation rule, they actually again went back to prior to 2020. That means now employers, especially if the nature of business is that if their employees provided services to third-party companies, either remotely or from their location or at the third-party location, then employer is required to provide documents showing there is a bona fide job offer exists at the time of filing from the start date of the for the start date of the H1B petition filed on the employee. So how do you establish that? Is they saying that you can establish that to the contracts, purchase orders, and other documents. Whichever documents you can think of viable option for you. That means client letters and everything. If you have a client letters and everything. So that's one important distinction happened right now. So in order to establish that you have a requirement for H1B specialty occupation in one of a job offer, which basically the term they're using is non-speculative employment, right?
Okay.
And non-speculative employment, that's what the term they're using. And so now again, as that was happening now, in order to file an H1B right now, especially if you, as an employer, if your nature of business is to provide services to third-party entities by your employees, then you have to provide contracts and purchase orders and work orders to show that there is a bona fide job offer exists for your employee in the specific specialty in which you intend to employ them. That is very important thing. And second thing is they changed the educational requirements for the specialty occupation. Previously, we were able to use for the specialty occupation to qualify generally educational requirements. See, the general requirements for the specialty occupation is a practical, how the specialty occupation is defined by the statute is very simple. It says that a practical and theoretical knowledge of a specialized in nature, and such knowledge can be attained only through the bachelor's degree or its equivalent, then the position may, in a specific specialty in which employee intends to provide services, then the position may qualify as a specialty occupation. That is what the definition. So because of that, we were able to use various degrees, even generic degrees also, to show that position qualifies as a specialty occupation. It does not have to be in a specified major. But with the new regulations now, they're saying that generic degrees may not qualify as a specialty occupation because they don't have any specialization in the degree, especially generic degrees like the liberal arts degrees or MBA degrees, where just business administration doesn't have any other specialization into that. Those kind of degrees may not be eligible. Just meet those degrees requirements for the position offered may not be eligible to qualify the position as a specialty occupation. So that is one significant change which they're explaining in the H1B moderation rule. So now the degree requirements for the position in which you intend to employ an employee should be directly related to the specific field of endeavor, which is related to the occupation in which is going to provide services. What does it mean is that if you're hiring somebody as a software developer, then your education requirement must be directly related to the position of software developer. And how you can determine that? Their advice is to look into the Occupational Outlook Handbook issued by the Department of Labor. They clearly, that handbook will determine or state what are the education requirements generally required as per the Department of Labor under the normal industry standards. Okay, that's how they define that. So that any degrees any educational majors you require, those majors must be related to each other directly. And that's how you have to define the requirements for the specialty occupation. It's all about the requirements of the position, not the qualifications of the beneficiary. We all have to understand. People get confused. Specialty occupation, he has 10 years of experience, he has a master's degree, then the position is qualified. No. If he may have 10 years of experience, he may have a master's degree, but if the position doesn't require a bachelor's degree or its equivalent in a specific specialty, and if the individual doesn't have to have a degree that is directly related to that specific specialty, then he may not qualify for the H1B petition because the H1B petition was not filed properly as per, and he doesn't qualify for the requirements of the H1B petition. So that is one significant change happening here. So it's very, very important, whoever is preparing H1B petitions for your lawyers or your company HRs or legal people, they need to understand each and every position very carefully and what the requirements are, and accordingly prepare the petition and submit those documentary requirements. Even supporting documents needs to be provided accordingly to the USCIS. Those are the things that are very, very important right now. And other thing is, so those are the things which are really coming into existence with the specific specialty requirement. And sir, how can we unmute everybody, Santosh garu?
Unmute or
How can we mute everybody? Because everybody, they're able to unmute by themselves.
yeah, I did mute all.
Thank you. Thank you, Santosh garu.
Yeah.
And so that is one important change happening with the H1B moderation rule. And also, H1B moderation rule is telling that they can actually approve H1Bs for the duration which they deem appropriate or which they deem that petition is approvable. That means, again, we can start seeing short-term approvals of H1Bs with the H1B moderation rule. Okay?
So 3 months, 6 months, that type of.
Yes, 6 months, 1 month, 2 months, 3 months. Again, that is a possibility. We do not know yet because we haven't received any short-term approvals as of now, but that is a possibility with H1B moderation rule. And with H1B moderation rule, one important thing what they have done is FDNS site visit verifications, right? Complaints reviews, FDNS site visit and complaints reviews by the USCIS and by the Department of State to verify that the H1B petition was bona fide, right? And previously, participation in the site visits by the employer and employee was minimal. It wasn't, I mean, was voluntary.
Voluntary.
It is not minimal, I'm sorry, it's voluntary. What I mean to say is it is not necessarily required that you have to participate in the site visit. And if you decline to participate in the site visit, they cannot force you to participate in the site visit, or they cannot use that against the either to adjudicate the H1B petition or to revoke the existing H1B petition. But now, with the H1B moderation rule, they made site visits mandatory. Participation in site visits mandatory. It requires employer and employee, not only just employer and employee, if the employee provides services at the third-party location, even the third-party companies must comply with the FDNS site verification. And if they don't, that information can be used against you either to deny the application or to revoke the H1B petition. See, this is the issue which many non-profit organizations like IT Server and everything, they're trying to file a lawsuit on it. And we have to see how it goes in the beginning, because I think the reason why I think we have a very strong case here, I think this non-profit organization may win this case because third parties are not subject to any benefits in this petition because they're not the employer or they are not controlling the work of the employee in any manner. So they're not involved in any way employing that employee in that location. So there is no way, if the third-party company does not agree to participate, you cannot use it against the approval denial of this H1B petition. I think that's overboard by the USCIS. I think those are the issues can be litigated. And I think I'm very confident that these issues will be litigated in the future and see some kind of relief on that. And so these are the things I record with the FDNS site visits. And because I'm talking about third-party companies right now, in the H1B specialty occupation also, to determine whether the position qualifies as a specialty occupation or not, especially if the employee provides a third-party site, and provided if that employee actually filling the position that is part of the hierarchical structure of the organization for which which employee is actually providing services, then USA is telling that actually is actually providing service to a third-party employee as their part of their organization. So he'll be deemed as an employee of the third-party company. Therefore, they will look into the requirements of the third-party company to determine whether position qualifies as a special occupation or not. So this can lead to several problems. One, most of the clients may not even say what are the education requirements for the position for which they're employing these individuals. Second, what if the client says this excessive requirements, which is actually differs from the petition what you're filing for the individual, because that will show difference in the wages what you're paying for the employee and actually the wages supposed to be paid with that excessive requirements stated by the client. And these are the complications will arise. So it's very important for us to understand what kind of an evidence we provide to the USAS to establish that employee is merely providing services to the third-party client, but actually not filling the position that is part of the hierarchical structure of the organization. Okay, if the employee is not filling the position that is not the part of the structure of the hierarchical or not part of the hierarchical of the structure of the organization, then you do not have to show the requirements of the third-party company. Only your company's requirements must be shown. That means if he can establish that employee is only merely providing services to third-party entity as your employee, as an independent contractor, rather than filling the position that is part of the hierarchical structure of the organization of the third-party entity, then you have no problem. You should be able to get away with it. But USS will try to pigeonhole everybody into that particular requirement because they want to deny the cases or they want to adjudicate very aggressively on these matters. So we as an employers and as an employee make sure that we provide information in such a manner or prepare or document in such a manner that they were not actually filling the third-party entity hierarchical structured position. Okay, hierarchical position of the third-party entity. So those are the requirements very, very important with the H1B moderation rule. And as we said, one more important one, with all these things we're talking about, one good thing happened with the H1B moderation rule for the H1B employees, okay, and the employers also. The thing is now, previously, if somebody is a majority stock owner, majority owner of the company, or he has a majority voting stock in that entity, they had a difficulty getting an H1B filed through that entity to run or operate that entity because of the control issue that has been stated in the Neufeld memo. Okay, because to show employer-employee relationship, the employer should have a control on the service of the employee. But what that Neufeld memo said that is, if the employee is himself is the owner of the entity, then he cannot differentiate himself with the entity because there is no separate control aspect over there because he's the one who's making decisions on how to perform or whom to hire and everything. Therefore, he may not be eligible by H1B petition if he's alone involved in the company rather than anybody else is involved in the company. But now, USC has went back prior to the 2011 policy. Now they're saying that even if you are a majority owner, 51% stock owner, or you have a majority voting stock, then you can still file an H1B petition from your employer from the same entity which you own, as long as the position qualifies as a specialty occupation and any job responsibilities you have as a CEO or a director or a owner of the company are ancillary to the job for which you are actually petitioning your H1B petition. Okay, and that H1B will be approved only for 18 months right now, and also will be renewed in the increments of 18 months. So that's actually a very good thing. Why it's a very good thing is I'll tell you, I'm the biggest benefactor of that regulation interpretation in 2008 and 2009 when I started my own firm in 2008. And because prior to 2011, this was allowed. That's why I'm very happy that they respected the corporate tenets of the corporate law, where it clearly defines that the entity is separate from an individual. Therefore, entity can actually petition an H1B for an individual. Okay, and I was a huge benefactor of that. When I started my own firm in 2008, in EAD, just to be on the safe side, I wanted to get an H1B also. And I filed my firm filed my own H1B for me. I'm the 100% owner of my firm. And I was able to get an H1B on the side because of that I was able to maintain my H1B and also EAD until I got my green card. So it's if you are an entrepreneur in nature and you have the ability to succeed, there is nothing wrong right now for you to establish your own entity. But only requirement is that you have to show that you have a bona fide requirement in a specialty occupation. You just can't park your H1B by starting your own company and doing other things, whatever you can do to make money. No, you have to make sure you have a requirement in a specialty occupation for the business in which you are actually intend to do through that entity. Very important. And if you don't, then it may result into denials and other things. So it's important to discuss with your lawyers and make sure that you get proper guidance on that. Review the petitions properly and properly prepared and file your petitions. These are complex petitions sometimes. Honestly, you may end up into willful misapplication fraud issues. So make sure that you handle them very carefully. So these are the major changes happened. I mean, there are a lot of other changes, but I think because of the time constraint, I just want to talk about these 4 or 5 issues with H1B motivation rules.
And the important point about this 14 years kids the registration, the alien registration, can you please let us know what is happening? What should we do?
Yeah, definitely. See, President Trump on January 20th, protecting and saving America executive order, I believe that is what the executive order is about, issued an executive order where they directed the USCIS and other agencies to initiate a form and made it a mandatory under Section INA 262, which requires every alien in this country must register with the US Department of Homeland Security. Okay? Or whatever the authorities they were at the time when the INA was passed. Okay? And so pursuant to that authority now, they're requiring all the aliens who are in this country must register, must be fully registered with them so that their biometrics are recorded. And for us, for our community, especially our Telugu community or Indian community per se, I would say that many of them entered into this country legally while they're coming into this country. Because they entered legally while they're coming into this country, they're already registered with the Department of Homeland Security. They may not require to submit a re-registration again for that, but only the people who may be subject to that re-registration is the children who come into this country prior to age 14 and they did not travel abroad after the age 13, after they attain age 14, then they are required to submit the registration. So any children that have not entered back into this country once they turn 14 and they are the children are required to submit the registrations with the USCIS. And it came into effect from February 25, 2025. But they said that they're going to introduce a new form to submit the registration online because every kid supposed to register an account online and then with the USCIS account online, and then you submit this form through that account to the USCIS. And if they fail to do that, especially if they attain 14 years of age and they're living in this country more than 30 days, and if they fail to do that, they can be subject to severe penalties as well as criminal offenses, misdemeanors, crimes also. Okay.
So when they are going to give the form links and all?
I think it's going to come very soon. They have not introduced the form. Even today in the morning also I checked. They have not introduced the form yet. We don't know what the form number will be also. We're eagerly waiting for it, but you can actually register an account online if that allows you to register, and you can try that one. So mainly who are impacting in your community are the children who are attaining age 14 and they have not traveled abroad and re-entered into this country after they attain age 14. For us, that is more important because many H4s, while they're entering legally, so they're already submit the registrations. So we don't have to redo anything with that. Mainly this meant for the illegal aliens who enter into this country without inspection and they stay in this country. And for them and their children who come illegal into this country, they are required to submit these registrations because they came illegally, no inspection happened to them while they're coming in, so no biometrics have been taken for them. So they are the ones who have to take care of it. But for children who come legally into this country, but if they come legally into this country before 13 and they do not travel abroad once they turn 14, then they're required to do the re-registration.
So quick
And
question.
one more important thing you have to understand is that if anybody above 18 years, they all have to carry the proof of registration with them all.
Banu, can you please unmute yourself?
Yeah, I unmuted myself. Sorry. I'm sorry. Um, what you need to do is, sorry, if you're above 18 years of age and you are a non-immigrant in this country, you're required to carry the proof of registration with you at all times. What do they mean by that is, what you do is make sure that you print out your I-94s and keep the copy of your I-94s with you all the time, electronically or invalid, whatever way is convenient for you. But make sure that you carry your I-94s all the time with you. And that's very, very important. That's what these registration requirements are, to show that you are legally in this country, you're maintaining. They'll be able to identify your biographic information, everything immediately without any problem. And because we're talking about the I-94 thing, this is very, very important thing which I want to talk to everybody.
Sorry, quick question on the previous topic.
Mr. Jack,
Yeah.
please
Yeah.
ask while during the Q&A session, please.
Sure.
Yeah.
Sure. Thanks.
Okay. Thank
Wait
you.
for the Q&A session. We'll open the platform. Let Banu speaks and give all the necessary information. Yeah, Banu, quick thing. The thing
I
is,
want to talk about the I-94, sir. It's very, very important
yeah.
because I don't know whether it's in the agenda or not, but I felt like it's very important to touch because we're talking about
Go ahead.
I-94.
Please go ahead.
And see, many times we see the problem with the individuals, especially in these days, because now when you travel abroad, when you enter into this country, the I-94 is no longer issued physically to you. They're updated online. And many people, when they enter into this country, they're forgetting to check their I-94s online. And because they failure to check I-94s online once they enter into this country, sometimes those I-94s have erroneous information in them, or wrong information in them, or a shortened term of approvals of a validity of I-94 than the I-94 they actually have in their hand through their I-797A, H1B approvals, or H4 approvals. or whichever status they're in, L2 or L1, any status approval petitions, they basically go out of status and accrue unlawful presence in this country. It's very, very important that these individuals have to verify once they enter into this country, make sure that they log into their I-94 system online and a printout of those I-94s and keep them with your passports. And also verify the information in the I-94, whether the information is reflecting truthfully or not. That means as per the updated information or not. Sometimes the reason why it is I-94s will be issued only for the duration up to the validity of the passport or up to the validity of the I-797A they have in hand, whichever is shorter. That means if the passport, let's assume that you have an H1B approval notice till 2027. However, your passport is only valid till May 2025. And you travel abroad because you have valid visa, and then you come back into this country on March 2nd, 2025. And you don't check I-94 because you're so busy in life. At least you think you are busy in life. That's why you don't check I-94. And what happens is they will update an I-94 only till the validity of the passport. That is till May 2025 only, not till 2027, September 30th, the date till you have your H1B approval notice. And because of that, what happens under last action rule? The latest I-94 that came into effect shall govern your status in this country. And in this situation, the latest I-94 is the I-94 that is issued for you online at the port of entry, and that came into effect last because the I-94 comes into effect on the day you entered into this country, and it's going to expire on May 2025. You are out of status from May 2025, and you start accruing unlawful presence. Expiration of I-94 will lead to accrue unlawful presence. Okay, and that will cause a huge problem for you and your family. We see this problem all the time with the H4 dependents. So please, all of you, my humble request is, please make it as a habit of logging into I-94 system once you enter into this country, printing them out, verify the information, see the validity of the I-94s. If any errors in them, immediately can approach the different inspections at CBP and get it corrected. So it's very, very important. And if you don't, if you have a short-term validity of I-94, then you have to either file for an extension prior to the expiration of the I-94, or if you still have a valid H1B petition, valid visa, you can travel abroad and then enter back into this country to get the I-94 until that H1B valid, or H4 valid, or L1 valid, or L2 valid, whatever state it is. Stated as it is. So it's very important for all of you to understand the importance of I-94, because I-94 is the document which actually determines whether you're in legal status or not the entire H1B petition.
Okay, got you. Got you, Banu. Banu, one more question about this the 14 years. They can able to log in from the USCIS website as their parent the credentials, or as the children credentials. What type of login they need to do?
If the child turns 14, then he has to open his own account.
His own account, children account only.
Yeah. If the child is below 13 years of age and if you have to submit the registration, then the parents will open account on their behalf.
But 13 years not required, right? But only 14 and above.
13 years are required if they enter into this country illegally and they've not subjected themselves to the inspection.
Oh, okay. Yeah, mostly our guys are legal. So, okay, I think thanks, Banu, for a real session. Guys, this is a Q&A session now. I'm going to ask all the questions, which are in the chat box. So I'm trying to go one by one questions. So please try to share as much as you can, and I will, ask the questions to Banu. And I don't want to open for all. Please, here the chat section would be better, or else it would become a big problem for us to handle the session. Okay. So there is one question. I have a family. My father-in-law is having a GC and stayed here for almost 5 years. Because of my family thinks he goes back for 3 years ago. What are the possibilities to activate GC?
Not much.
Not much. Okay, thank you. The next is about consulate process, H1B consulate process. Can you please explain about the consulate process of H1B?
Consulate processing of H1B means when if you're in this country, United States, or abroad. Actually, if you're abroad, then it will be always a consular processing for you on H1B. So I don't see the reason to explain that one. But if you're in the United States on certain status like H1, H4 or H4 EAD or L2 EAD or F1, and if you apply for an H1B petition without seeking change of status to H1B in this country, without seeking change of status to H1B in this country, that means you're asking the H1B to be approved so that you will go abroad, apply for a visa for H1B, and enter into this country on H1B. That is what consular processing means. Consular processing means if H1B is approved, you are required to go abroad to the consulate, get a visa stamped, and then come back into this country on H1B visa to work under H1B status.
Okay. So if an OPT student has been applied for H1 for this new CAP 2026 and he got approved, and even though before October, after October 1st also he cannot be on H1 until or unless he go to out of the country and get stamped, his status would be still OPT, cannot be an H1.
Yeah, provided that he actually requested for the consular processing.
Oh.
Okay. But if he does not request for the consular processing, if he only requested for the change of status, and if the change of status has been denied because he failed to maintain status in this country and approved the H1B for abroad, then automatically his service will terminate because USA has found that he is in violation of his status. Then he's mandatorily required to go abroad, get visa stamped, and then come back. So it's a circumstantial. So most of the times, if the individual seeks for a consular processing in the beginning only, then the scenario what you said is true.
Okay. And H4 to F1 conversion, is it safe to change the status within the country or suggested to attend the consulate?
I don't see any problem changing the status within the country.
You can do happily.
Yeah.
Then some light on registration. I think mostly we covered on the alien registration initiatives. Most of the people asked on that question actually. That was a surprising part. And one
No,
more.
that is not a surprising. Actually, that is a very important thing. That's why I'm very glad that people are showing interest in that.
Yeah,
Because unnecessarily, otherwise, these kids can be subject to penalties and the criminal offenses, which will ruin their career and everything, which is not required. So this is a very important one. I'm very glad that people are taking it very seriously, and I'm very glad that I'm the first guy who brought the awareness about this for the entire community. I'm very happy. For
And
that.
this was actually in our actually Texas chapter. There's a heavy discussion happened on this topic in this week actually. So, so we were also not quite shared some of the things from the USA's website also. I saw that that link was not there. Even I was also struggling to find out for a few of our immediate family members they need. So I was struggling to find out. Then I thought that is not really published so far. So
Not yet.
yeah.
Not yet. The
And,
forms have not been published yet. Yeah.
this one actually interesting question, but it is not legally, I feel. But I'll ask this question. The extra income generated by H1 with 1099, is it allowed legally?
What kind of a 1099 it is? If it's a 1099 NEC, it's a problematic.
Mm-hmm.
If it's a non-employment compensation, then it's a problematic because he worked unauthorized. H1B is an employer-specific visa. That means he can only work for an employer who sponsored an H1B. He or she can only work for an employer who sponsored an H1B for them. And that has to be on a W2, not on a 1099.
All K1s are okay, right?
K1s are okay. Schedule C income is okay. No problem at all.
Okay, fine. If an individual has used their final attempt for H1B registration under the regular cap and was not selected in the lottery, do they still have an opportunity to apply for cap exempt H1B through a non-profit organization, since such organization can file petition year round?
Answer is yes, but you have to understand not every non-profit organization can file an H1B petition. Only the non-profit organizations that are usually considered as an institution of higher education, or their affiliated entities, or a non-government or a government research organization. where their primary responsibility is conducting the research. Only those organizations can qualify as a CAP exempt organizations, and they can file an H1B petitions for it. Not every nonprofit organization qualified as a CAP exempt organization. Just have a clarity on that.
Okay, so one more guy graduated on May 2024. My F1 visa has been revoked due to DUI case. While ongoing case, my OPT got approved and I have received EAD card with active service status. My OPT period starts on July 8th, 2024. For the case to be dismissed, you need to complete PTI course, which I already began. This will end next May 2025, and the case will be dismissed, proven non-guilty. I need to know this is going to affect my maintaining visa status in any way to apply my STEN OPT and running payroll of my payrolls.
No, not really though. See, the if somebody has a DUI, automatically Department of State will revoke the visa which they've issued to you, and that's what happened to you. But revocation of a visa in the passport does not render you unlawful in this country. You're still legal in this country. Only the time you will be unlawful is if the USCIS or the immigration judge determines that you are in violation of your status. Okay, so that's the reason why you got your EAD, you got approval and everything. And if the DUI, as you said, if you're taken a probation, and for the immigration purposes, even if the dismissal of the case after completion of the probation, still it is a conviction if it comes to immigration requirements. Therefore, you have a responsibility as an individual rest of your life whenever you're seeking a benefit at the consulates to apply for a visa or anything like that, to disclose that you had a charge, you have been arrested and charged with the DUI, and the results of the DUI to the consulates or to the immigration authorities in the US. And also, when you travel abroad, most of the times, Department of State will require you to provide a medical certificate from the doctor saying that you're not habitually drunkard. Okay,
fine.
so that's what happens.
I'm green card holder. Last year I came to India to take care of my parents and in-laws due to their health issues. At that time, I applied for I-131 process, but the status has been not updated yet. Now I'm planning to return on March 30th. What is my situation regarding this travel?
See, there is a presumption that he abandoned his residence because he stayed more than 11 months abroad. Okay. And he needs to prove that he never abandoned his residence in the US. That means during this 1 year, if he filed a tax return as a non-resident in the US, that can cause a problem for him because he needs to establish why he did not maintain residence in this country. What was the reason? Okay. And so if anybody stays more than 6 months outside the country, they have a burden to prove that they never intended to abandon the residence in the US and they're still continuing maintaining the residence in the US, but there were circumstances that were beyond their control. Therefore, they have to stay more than 6 months outside the country. Same thing in this case, because he stayed more than a year, they may deem that he actually abandoned his residence. He needs to overcome that. So ensure that he takes care of, or he takes all the documents that are required to show that he was forced to stay there because his parents' health and his in-laws' health were not good. So therefore, he was required to stay there and take care of them and everything. And if it doesn't, and if he's a little bit lazy in carrying these documents and this evidence and everything, sometimes they may not let him board the plane also. And also make sure that he's maintaining a house here. If his family is here, he needs to document all that information also because he has to prove that he never abandoned his residence.
Okay, fine, thank you. So my kid has done biometric at the age of 13 in India. Now she's 14. Do we need to still to register?
Yes,
Oh, okay.
because she turned 14 now.
Yeah, okay, thank you. And I'm planning to have a baby in October. By the time there is a birth for citizenship. Yes, I think.
We don't know. We don't know what will happen in October. It's too far from here. Right now, there is a temporary restraining order in this EVO, and because cases are pending with the courts in Seattle, Maryland, and various other courts, 29 courts actually, 21 courts, I believe. And one of them, Trump administration took it to an appeal to the Court of Appeals in Ninth Circuit, saying that there's an emergency needed to remove the temporary TRO to implement this EO under the national security. But the court did not agree that because court said that you're trying to make a changes to the amendment, you're trying to amend the constitution with this EO, and therefore let the court decide on the merits. That's why they kept the TRO intact. But now uh, Trump administration is trying to file an appeal with the Supreme Court, and we know what the Supreme Court is right now. We have some judges who are very much in favor of him. Whatever he does, they will approve it. So we have to see what the Supreme Court will do. But very likely the Supreme Court will not overrule the decision by the Ninth Circuit because they know that it's utterly unconstitutional what Trump administration is trying to do with the birthright citizenship.
But actually, why Trump no, right? This is not an cannot be done with the signature. So, but why?
No, see, the point you have to understand this. See, we can't enter into politics in this call because politics is entirely different ball game and it's not relevant for us. Okay, he's trying to implement the policies what he promised during his campaign, and accordingly he's acting. Whether those promises are legal or illegal, he's not caring about it. Okay,
Yeah.
and that's why we have. Fortunately, we are in a great country in the world. We have separation of powers. We have checks and balances, and hope judiciary is still independent and from the executive, and then judiciary will do its job on how to interpret the laws and how to protect the laws of the nation. That's all I can say.
Okay. The second question is about recently I saw this is from my personal side question. I saw the other day on February 27 there is a case filed against Department of Homeland Security versus Save My Jobs America on this H4 EAD against the EAD H4 EAD.
There is no. I don't think there is any case filed. I don't think there is any case filed.
It's filed on 27th February.
Yeah, I honestly I'm not privy to the. It's just 2 days ago. I don't know about these cases because these are all sham cases. I don't think any judge will rule against the in favor of that cases. But I do not know. Honestly, I have no idea about that case, so I cannot really comment.
Sure. I'll touch in offline about that. Okay, so the second question is about mostly on the this. A lot of people are questioning about this H4 turn 14. My son is on H4 and turn 14 recently, and it's already past 30 days. What should I do now?
Okay, wait for the USAs to announce the new form, and once they announce the new form, make sure that you open an online account for your kid, and your kid submits the registration through that online account using that form.
My H1B is in the consulate process picked from an ex-employer. Can I work for Y employer for my whole OPT?
I'm sorry, can you repeat?
My H1B is in consulate process picked from an ex-employer.
Mhm.
Can I work for Y employer for my whole OPT?
Why not?
Okay. I entered USA in 10th July and my H1 expires on 30th September 25th. What is the period I will get when I go for extension?
How
Yes.
many years? How many years you already exhausted in 6 year duration?
I think he entered only on the 24th, but see, they expired on 25th. So he's going for an extension for the next term. So I think
Usually it's 3
all
years.
our
No?
documents.
Usually it's 3 years.
3 years, yeah. Below are some details. Oh my God, so much. Pass this question. Stamping on visa 15th November to 30th September 2025. Latest approval June 23rd to 4th June. After this H1 approval did not go for stamping. Use only stamping only to travels. But what is this question? I don't understand.
Yeah, sometimes we don't understand. Just we skip on them, sir.
Okay. H4 kids to H4 kids to F1 visa. Will I have any challenges for F1 visa stamping in India as parents are in USA?
See, I always believe that they may have more challenges compared with the regular F1 students who are coming from India. The reason, I mean, of course, some lawyers are saying they've never seen any problem. Children are getting visas and everything. But I would not dare to send the kids for the stamping for F1 visa, especially when they're turning age 21 and they are in this country on H4 for several years. And their parents are in this country for H1Bs for several years. They don't have any ties to home country. and it's very difficult for them to prove that they intend to return to home country at the consulate than the what you can prove at the USCIS here when you file for a change of status here. So I always encourage people to file for a change of status here for F1, especially if the child is turning 21 and the child is in H4 status. But it's up to them if they want to listen to the lawyers who tell them that. And if you get stuck in India, don't blame anybody else. But the point is, the reason why I say that is, I have a lot of respect for those lawyers also who say that it's okay to go because legally they're not wrong. But I'm talking in a practical point of view over here because H4 getting a visa at the consulates is discretionary in nature. Same thing with change of status also, it's discretionary in nature. But adjudication by the USCIS is always more reasonable than issuing the visas at the consulates abroad. So that's why, and also you staying in this country, even if your F1 change of status gets denied, at least you'll have an option to do something because you're already in this country.
Yes.
So yes, you can legally go abroad, get visa stamped, and come back. There'll be no issue. Generally, should not be an issue as long as you meet the requirements, as long as you establish the ties to home country. But if you have an opportunity to file for a change of status in this country, I would advise you to do the change of status in this country rather than going abroad for the stamping. Just for the sake of few $100 here and there, don't do those kind of things. You can cut down those $100 in your alcohol bottles or in your groceries or something like that. But it's important you need to spend that money for your legal matters.
Okay, good, thanks. For GC holders as well, kids turn 14 need to be registered.
No, only non-immigrants.
Do we need to update or replace SSN after getting GC?
Yes, you have to update USCI SSN after getting a GC because in SSN there will be annotation always saying that DHS authorization need only and everything. Once you got a GC, the annotation will be taken off. That means your SSN card itself will act as a proof of employment. So it's very important for you to update SSA office, and then get a new SSN card without such annotation.
If F1 visa is revoked, can we reinstate from USA?
F1 visa revoked. See, that's the problem. What they're talking. Visa means visa in the passport.
I don't know why it is revoked now. I'm not confused.
No. If visa is revoked, then they have to go for the stamping abroad.
Mm-hmm.
So is he talking about the? That's why I wanted to know exactly what they're talking about.
Yes. Okay, Nazar. I was told that we don't need to register for kid who turned 14, but now for the recent question, the answer was yes to register. I got confused. So Shankar, I think it was to turn 14, you have to register, but it has to be, the links has to be enabled, but as of now, create an account for your child. And then once it is enabled, you can start applying.
But there was something like we already entered legally, right? So we don't need to register, right? That's what I got the answer.
Mr. Shankar, if the kid entered into this country once he turns 14 legally, then he doesn't have to register. But if the kid entered into this country prior to the 14 years of age and he did not leave the country and he turns 14, then he requires to register with the USCIS.
Got it. All right. Thank you.
Thank you. Then if we are on STEM OPT, can we travel to India with the last 6 months or 1 year of STEM OPT expiry? Yes, you can.
You answer.
Yeah, okay. Please suggest when to go for stamping. I'm legally eligible to stay in US after September 30, 2025. Anytime, whenever you like. Can we start I-140 process like filing for LCA while we are STEM OPT and waiting for H1B? I think you can. There is no thing like.
Is he talking about the labor certification or is he talking about the labor condition application when he said LCA?
When we start I-140 process, like filing for LCA, what? It's all too many mix up.
Probably, I mean, he's talking about labor certification, home labor certification. That's what I'm saying. There's some, I mean.
Yeah, GC basically, like perm certification.
Yeah. Answer is yes. As
Yes,
an
yes,
FS2,
that's only
yes.
I'm
The
telling.
employer can file a prompt certification, yes.
Your H1B process and your GCs are two independent. They are not interlinked. So as long as you are on a valid thing, you can apply. And there is nothing different. Then next, stamping on visa 15th September was done based on latest H1B approval. After this approval, when to go for stamping on EJ? So your passport is on until September 30th, 2025. You can eligible to stay. See, passport is different. The visa is in. See, there are two things happens in US. Your visa and your H1B approvals. Your visa is to enter the country and exit the country and come back. That is a one visa. And H1B approvals, you can once you land in the country, you need to maintain the status, and you need to, as long as your status of H1B is there, you can stay. There is nothing
So,
depend.
so I think are you talking to Mr. Jack's question here? Which question is that one?
This is about Suresh. I think he asked me directly. So this
Okay.
question is like, I'm just put here. I'm putting here to everybody. No, I cannot send chat to Bano. I'm sending you, Bano, this question to
Hmm.
you.
Answer is yes. He's legally eligible to stay in this country because his H1B is valid till 4th June 2026. And his latest I-94 is the issued on 14th June 2023 because his latest I-94 came into effect from June 14, 2023. That governs his status. So he's authorized to stay until 4th June 2026. However, if he wants to travel abroad anytime in between, then he can travel abroad, apply for a visa, and he will get a visa until 4th June 2026, and he'll be able to come back. There's no particular time frame then when you have to go and everything. After September 30, 2025, yes, he can continue to stay because it is latest approval I-94 ends on 4th June 2026.
Yeah, that's only I said. Yeah.
And other thing about that, there's one more question similar to that, Mr. Jack. He asked the question saying that when I enter US, I got I-94, which is valid until my passport expiry date only. But my H1B extension had a future I-94 date for valid from and valid to. So I should be good as my new H1 started as an oh is another month. I would prefer you providing the exact dates over there to answer that properly.
Yeah, please share, Jack. My cousin is working for university non-profit, but university is not sponsoring H1B. What are his options?
His option is like anybody else. Find an employer who's willing to sponsor him H1B.
I think Rahul, your case has already discussed about the DUI case. My visa was revoked. Reinstate from here, and what else is the options? Okay. Now about EB5 going to end soon. Is there any confirmed news on that?
No confirmed news on that. I'll tell you one thing. President Trump cannot repeal EB5 program because it is only Congress can do that because it's a law. It's a statute. It's a law passed by the Congress. Only Congress can repeal such a law. So Trump government cannot end the EB5 program. Okay,
And what about the replacement of golden card?
that they can propose. They can do that. So, but you have to understand this. There are two things you have to understand with the presidential power if it comes to immigration. Okay, president can choose anyone whom he wants to grant a U.S. citizenship. Okay, because he's the president, he can waive all the security clearance and he can determine, I want Mr. Santosh citizenship. I want to give citizenship to Mr. Santosh because of I believe it's in the best interest of the United States. As a president, I can do that. But I cannot say that the law which is passed by the Congress, I'm going to overrule that because you already signed into the law and went into the law. Once it becomes a law, which is an EB5 program, president cannot say now, I will revoke that law or I'll repeat that law because he already signed into the bill law. There are restrictions on that. Executive authority as to different from the congressional power of passing the laws, because EB5 program it's a law. It's not a policy or a procedure. So we have to see whether the gold card will be a law or a policy or a procedure which will be implemented by the President Trump right now. Okay, obviously President Trump proposed gold card in place of EB5 program. So eventually EB5 program will be removed or curtailed. For that, Congress has to repeal it. Because he has a power and control in both the houses, it's likely that the Congress may repeal EB5 program, but we do not know that yet. Okay, it's too early to panic because we don't even know what his gold card requirements are.
I think Jack came back. I think Jack, I think my I-94 when I entered in US is valid until 25 Jan 2025. My H1 approval I-94 is 2027. So, so I think when I enter into US, I think this is the one, right? Can you see this Jack question, Banu?
Yeah, I think this is I think it's a problem because his I-94 expired on January 25,
Already. Correct.
2025.
Yeah. So already remember always
When
it's
did you? No, the whole point is when did you last
landed.
time enter into this country? What is the date? You need to
So,
provide proper dates, Mr. Jack. When did you last enter into this country?
so I entered into US in June 2024.
June 2024, and that
Correct.
I-94 was given till 25th January 2025. Am I right?
Correct. Yes.
But then your H1B is approved after you entered into this country in June 2024. That is valid from 7th July 2024, right?
Yeah. So my H1 was approved before I went to India.
I understand, but the I-94 came into effect from 7th July 2024.
Correct.
Then you're okay. Because it came
Okay.
into effect after you came back into this country, then you're okay.
Oh, okay. Okay. I just want to clarify that because it's already stamped by the officer and this is just an electronic copy. Does it override the previous
No. Because this
electronic
I-94
copy?
came into effect after you come into this country.
Correct.
That's why this is the latest I-94, which governs your status right now.
Oh, okay. Thank you. Thank you very much.
Sure, Mr. Jain. Yeah.
Okay. Jack, what is your full name?
It is Jagilanki Ashok Kumar.
So regarding my previous H1B consent process, can I travel to India during my F1 OPT and come back with OPT itself without H1B stamping?
Yes, if they want to work on OPT, yes, they can do that.
I think we covered all the question. Let me check in the forms.
Yeah, I'm pasting there. Santosh, you can go with them.
Yeah, almost we covered my child. Oh, okay. So there is one question. I'm reaching out on a serious legal matter involving employment fraud and coercion by a consultancy. I'm working full-time job, explored a job switch through a consultancy. During the process, consultancy provided a fake green card to clear the interview. I was forced to be allowed to a replacement someone I don't know to take the job in my name. On the first day, the replacement was caught as a fake person leading. Question it is leading to an investigation.
Santosh Garu,
Yeah.
that's a matter which I need to know the facts very clearly before I can advise in a public forum.
Okay.
I would prefer the individual calling me, and
Yeah, Manish,
but
please
I
call
can,
to
I can provide my contact details. My contact details are my office number is 703-496-7722, and my mobile number is 319-400-0053. My email ID is bhanu@bbilawgroup.com. Feel free to reach me during office hours, Monday to Friday. I'm very happy to discuss in detail because these issues, I need to know the facts with clarity. So we need to spend some time on it. It's very difficult for me to answer any question in this forum because it's not going to end up with one question here and that.
Okay, that's so a few more questions coming up. I think we'll wind up last two questions, guys. Do you have an update if my passport number expired? Passport number expired and I renewed it in US. do I have to update I-94 if my passport number expired and renewed in US?
No, you don't have to, but make sure that your I-94 is valid till what date? Because you have status only till validity of your I-94. If your I-94 is expiring very soon, then you may have to file for an extension because your facts are not clear. Just because you renewed your passport, you don't have to update your I-94.
What are my rights if employer is forcing me to go through consular H1B process instead of filing the petition after my registration was selected in the lottery?
You have no rights for it. It's an employer's wish. If employer doesn't want to file your H1B, you can't question them why they're not filing an H1B. But if they're doing that to harass you or to intimidate you or anything like that, if you have any hostile environment in the company, then you can actually pursue those claims. But it's up to the employer whether to sponsor you H1B or not. Nobody is entitled to H1B in this country. Okay? It's up to an employer whether they want to hire somebody in the position for which they want to hire somebody, whether it's you on H1B, whether it's somebody on F1, whether it's somebody on EAD or somebody on green card citizenship. It's up to the employer. Okay? Because employer wants to do a consular processing, you don't want that, then don't work with that employer. Find an employer who's willing to sponsor H1B, change the status in this country.
Okay. Oh, this question I can answer. Actually, I know this question. Can two legitimate unrelated companies admit H1B and it got selected? And it will be already Banu informed me that it would be informed to both the employers. And I think he can choose whatever he like, right, Banu?
Yes, if they're legitimate employers, answer is yes.
So, Banu, can you please message your? Yeah, actually, we shared, guys. Banu's when we shared this, Banu's email ID, Banu's contact number, and Banu's office name, and all the details have been shared in the link which we shared. But for your
I
information,
can type it. I can type here, sir. Just like
yeah,
anyway, office phone number.
I think vote of thanks, Prabhakar. Do you want to say vote of thanks, Prabhakar Kunda?
Yeah. Before that, there is one more question. Somebody posted, my kid turned 18, still on H4. Good to go to India for visa stamping, or do you see any issues?
I don't see any issues, sir. It's a very common thing.
Okay. Yeah. Thank you, Banu sir. Thank you for accepting our request and
Thank you, sir. I
for
just posted my contact details here in the chat
sure.
box. Everybody can look at those things. Thank you.
Yeah. Thanks for your marathon, almost 2 hour webinar.
Whenever.
Appreciate your time.
Thank you, Prabhakar garu. Really appreciate it.
Yeah, thank
And
you.
thank you, everyone. Have a wonderful
Thanks.
night.
I have to be very thankful to Banu. He traveled just now from Seattle and he joined the session. Yes, actually, it was so great and privileged to have you and have an informative session, Banu. Thank you, and we will trouble you in future also, guys. For your all immigration needs, please approach Banu, and he will always there for your any H1s or any other issues or filing GCs are there. Anything EB5 also Banu can help us. So please approach Banu. He's good to go guy. And Banu, before you leave, gets any inputs from you guys to how to approach you? What are the things we need to do to get help from you?
Hello.
Banu, Banu, unmute. I have muted everybody. Just unmute
Yeah,
yourself.
I couldn't understand what was the question because of the noise came in the end.
No, like our audience wants to reach you, and what are the things they can approach you? What are the various things you can help them?
So they can approach me for any questions they have with their immigration matters. I'm available on my phone all the time. And if I don't answer my call, just text me, and put your name, say that you're from NAPA. I will definitely will get back to you. And the other thing is, at the same time, you can send an email to us if you want to have for a lengthy conversation or something like that. Absolutely reach my office at a time. Tell them that you're from NAPA. We'll try to do, if you can afford unpaid consultation, we will do that. But it all depends upon how important that issue is. And for the unpaid consultations, usually our paid consultations also very less, very cheap. And if you utilize our services in the future for your immigration matters, we give credit that paid consultation fee also. But those are very small things. Sir. Main thing is if you have any questions, please reach to your lawyers, whether it's us with somebody else or anything like that. Don't listen to your friends and families. I don't think they don't have any ill will against you. but they're not expert in immigration laws. They're only telling you what their experiences are, you know. And also, if you're doing a research, start doing research from the reliable websites, not from the unreliable websites. Okay, because when you Google it, because the way the algorithm is written in Google, you get a lot of unreliable websites in the beginning. So make sure that the information you're getting is from authenticated sources or not. Those are the things which I really advise you. Anytime, sir. You're always welcome to reach out to me. Just mention your name and you're from NAPA, and I'll very happy to get back to you and able to provide whatever assistance I can provide you for you all. And I really thank you for making me part of this NAPA, Santosh Garu, and everybody in NAPA administration. And thank you all.
Manu, you know what? NAPA is having around 5,000 registered members in US.
Wow, that's a huge number.
Entity.
A huge number, sir, huge number. And
Yeah,
I'm
it's
very
still
glad. I'm
very
very
large.
glad, sir. I'm very glad.
Yeah, thank you, Manu.
Thank
And
you.
it has been published to all of NAPA group for your organization, and thanks for all the support.
I appreciate it, sir. Thank you. You all have a wonderful night, sir. Thank you.